Welcome to Heartbreak and Hope with Pat Barbarito, the show that explores how to build up or break down any relationship with confidence, clarity, and compassion. So in the 40 plus years of being a divorce lawyer, I've never been witness to the end of a marriage that didn't come with heartbreak. I mean, no matter what the reason. No one ever gets married thinking it's going to end. Why else would we say those vows, until death do us part, for better, for worse? I know that from my own marriage, as much as I knew it should end, the end was really heartbreaking. And what intensifies that heartbreaking is the black hole that most people feel when they end up in the courtroom arena. There's such a mystery surrounding judges and the courtroom and decisions. And when people walk into that courtroom, they're admitting they have to rely upon a stranger, a judge, to decide their family's fate. It's terrifying to rely upon someone to determine your financial future, your children's future, where you're going to live, how you're going to live. Let me make one thing clear, however, and we'll talk about this today. Litigants don't have to rely upon courts to make decisions. They could come to their own terms. However, as you'll hear from our guests today, when emotions are running high, often people are incapable of making their own decisions and they rely upon third parties. So no matter how capable you are of making your own decision, and ultimately most cases settle, the court usually has some role in assisting divorcing couples to reach that agreement or decide what the terms of their divorce will be. I've often said to clients, judges can't make bad people good people. They can't make inattentive parents attentive parents. And they certainly can't make people who didn't save enough money or plan for their financial future have more money to divide. And I think the hardest thing that I've said to clients is that most times judges don't punish people for being lousy spouses, or for having affairs, or for not being nice, just not part of the job. That's heartbreaking. Today, we're going to confront head-on the judicial perspective. With us is Judge Michael Casale and Judge Marie Lihotz. Judge Casale had a long and distinguished career as a Superior Court judge in Essex County, New Jersey, one of the busiest courts in New Jersey. He served in many divisions, criminal, civil, and family during his 20-plus year career. He's now retired, and he focuses on mediation and arbitration. His vast experience will certainly give us a unique view from the bench. Judge Lihotz served as a trial judge in the family division and was presiding judge of the family part in the Burlington vicinage of New Jersey. She went on to become one of the most senior judges of New Jersey Appellate Division. She's well regarded and well known as an author of many impressive and groundbreaking decisions. She also serves presently as a mediator and arbitrator at this stage in her career. In their respective roles as judges, these two judges have been witness to thousands of shattered lives, people who have appeared before them looking and searching for guidance. Today, we're going to talk about their experience from the bench. So let's start with you, Judge Casale.
Good morning, Pat. Good morning, Judge Lihotz.
Good to have you with us. Judge Casale, when a litigant has appeared before you as a family judge, and now, of course, as an arbitrator, it's no secret that, and particularly at that first appearance, they're in the throes of fear, of panic, and with that comes a lot of anxiety and depression, and they're looking for someone to solve their problems. What do you do, particularly at the first appearance, to communicate hope, or can you communicate hope?
Well, first of all, I alone cannot solve their problems. I can propose a plan for the family to move forward and also give a preview of how this case is going to proceed. And that first court event is met with trepidation by the parties. It's their first time into court. It's their first time meeting the judge who's handling their case. But we need to go forward with a plan. And I tell them one way or the other, you're going to get divorced. It's either going to be you deciding how you're going to get divorced by way of a settlement agreement, or I'm going to decide that by way of a trial. I don't know you. I don't know your children. I don't know your finances. By the time the case is over, I will know a lot more. I will explain the process, how many court appearances are going to be necessary. They need to comply with the discovery requirements, and they need to meet with their lawyers. And eventually, we're going to get through this, and while now there's trepidation, at the end, there will be hope. I've seen many a litigant have a divorce party. I've also seen many a party in my courtroom when they settle their case and I put through the divorce, shake each other's hands and even shake the other party's lawyer's hands.
So you raise a great point, which is knowledge is power. When we know what's going to happen, when we have a roadmap, we feel more powerful. And I've seen you do that when you were sitting on the bench. And I do think that gives people hope because they feel some control. But sometimes people don't have the resources to know how to put one foot in front of the other. And I'm wondering, Judge Lihotz, what you think your job is when somebody has been before you that is lost. I mean, you could give them a roadmap, but if they don't know where to go or who to talk to, do you think it's your job to provide them with resources? Do you think that's the court's role?
The court's obligation has to be even to both parties. So there can't be a favoritism towards one or the other. But most of the time in relationship breakups, one person has gone through the process of deciding they're going to file for divorce and move forward. The other person has to catch up. So you're always going to have a disparity in terms of where people are in their emotional process. And that's hard. But I do think that the courts have available to them lots of resources, and they can explain to the parties things that they can engage for themselves. Sometimes because you can't really direct one party or the other, in a conference, the judge should talk to the attorneys. I know in the county where I worked, they had what was known as the Women's Opportunity Center for what they called displaced homemakers, someone who probably didn't have the knowledge and the information about finances and what to do or how to even move forward. There's a lot of resources in terms of mortgage availability, programs that people can start from the very beginning, assuming they want to assume responsibility for the former marital home. We have programs to help the parents decide custody issues. I know specifically, again, I worked in 2 different counties before I went to the appellate division, and there was the parental program for people who are engaged in custody fights. I went to that program. I talked to the parents. So when they see a judge there and the judge is telling them the alternative of having a court decide versus having them decide, a lot of times that's really impactful. And I think that it does give people insight as to where they can go and what direction they can follow.
I know those resources exist, but do you think most judges communicate those resources, and or do you believe it's the job of the judiciary to communicate that to litigants?
I think the judges should, because I got to believe that there are times when you have attorneys who may or may not know, and what if they're self-represented litigants? So I do think that the court has an obligation to provide some of that information. I know recently in our state, they've actually required people to be informed about alternative bases to resolve their litigation. Alternative dispute resolution has really blossomed, and they want people to know that there are other ways of solving the problem than constantly going to court. That process is emotionally draining and financially expensive.
I also think that when people get to the point where they're in front of a judge, there's this paralysis, this emotional paralysis that exists. We see it as lawyers. They don't know how to put one foot in front of the other to make their way through, to make decisions. And I want to talk to both of you about that, because emotional paralysis is a reason that many cases don't resolve themselves. And I'll tell you, when I went through my own end of my marriage, I was a well-experienced, well-capable, competent attorney. But even I, having been in the system thousands of times, was terrified about the idea of not being able to control the outcome of my own end of my marriage. I'm wondering, when people come before you, and I'm throwing this question to both of you, and they're numb and they have that catatonic look because their life is dissolving, how do you communicate to them that they're going to be okay? Or do you say, I don't know, I got nothing?
Well, Pat, first of all, I think I have to differentiate from being on the bench as a trial judge as opposed to mediation. In mediation, we have the time for these litigants to spill their guts, to have a catharsis. I tell them, if we were in court, I might have 20 cases on this morning. You're my case. When we're done with this case today, I move on. So in mediation, they have a chance to finally get off their chest everything. But then I tell them, look, okay, I understand, but now we got to get down to business. You don't have that time in court. You have too many cases. However, you have to be human as a judge. I tell them, look, I understand this is a very difficult time for you and your family. You've been married for X amount of years. You've been out of the workforce for X amount of years. However, now you're going to have to take on a different role for yourself and your family. And you could complain about the fact that your spouse cheated on you. That gives you the cause of action. That's not going to affect how this case is going to get resolved.
Well, that's frustrating for people.
It's frustrating for people, but we don't have the time to act as counselors on the bench. But there are the support programs that Judge Lihotz was talking about. We have pamphlets right in our courtroom, and we direct them before they leave at the first case management conference. We say, go to that table back there. There's a list of resources for you to help you get through this difficult time. And right now, individuals going through a divorce, they're worried about their health. They're worried about their family health because of the pandemic. They're worried about their financial future. How are they going to stand on their own 2 feet? But I tell them, eventually, you're going to get through this with the help of your lawyer, your family members, and your friends. And then at the end, you're probably going to have a divorce party with your friends.
You raise a couple of good points, which is that judges are human. My experience has been, for the most part, the humanity comes through, although they have a job to do. So let's talk about that job to do. Judge Lihotz, what is it that a judge could do from a practical point of view that could get people through this financially and with regard to their children?
In the courtroom, I think that the parties really need to recognize that the judge is an objective observer. They know different things that are problems that they've experienced in their marriage, things that they challenge as insufficient in their former spouse. But judges are objective, and they're looking at people based upon the presence in the courtroom and based upon what they read in papers. From that, there are certain assessments that can be made early on. And if they're done in a positive way, as opposed to a negative way, I think that that can be helpful. One example, if someone has extremely successful education credentials, but maybe they haven't worked in maybe 5 years, maybe 10 years, the objective may be, if their age and health suggests that they have to go get another job, but they might have to get retraining. So from the very beginning of the case, and I think Judge Casale emphasized this, in the beginning of the case, you try and lay the groundwork and say, look, you're going to need to do this. Maybe I'm not going to order it right now, but I may order it in the future. And you're going to have to start yourself. It's better to start yourself and do it the way you need to do it than be forced to do it the way I would order you to do it. And Judge Casale also makes a very good point. In mediation, there is an interaction between the mediator and each separate party. I mean, sometimes you have everyone in a group together, but other times you just deal with one party and perhaps their legal representative. And there you can get that emotional connection with the litigant, and they trust your judgment. So when you give them objectively, when you say to them, I think you need to look in this direction, I think you need to do this, I think you need to do that, they take it very seriously. And I think that that's important. So whether it comes from the bench or whether it comes from the mediator, you help guide them so that they can stand on their own 2 feet. And that's the most important thing.
So one of the things that judges can do is enter court orders about money. You should pay this much. You should give this much. You should divide this much, whatever. And I've seen one of the biggest frustrations in my clients is when there is a court order, they think, great, it's done. And then they're not enforced. Now, this isn't a criticism, but it is a reality. Can you throw people in jail? Can you make them pay money? Can you find money that's hidden? How do you make people feel validated? Because isn't that what people are looking for? They say, I know she's got this money hidden. I know he makes this much money. What could you do to make people be good and compliant and responsible?
It takes a long time from the time the support order is not followed to the time the actual hearing occurs. Look, I was on the criminal bench in Essex County in the adult criminal courts for 10 years. So I'm used to having people go to jail. The times that I have done that on the family court bench, by the time the obligor, the payor, got to the Essex County jail, the arrears were paid. They did not
Okay,
want to
do you have
spend
the
money.
power? Judges, do you have the
Sure.
power to put
If you-
somebody in jail? It's a civil court, do you?
Yes. If you believe there's a willful violation and an ability to pay, you do. And one time, I knew that this payor had a lot of cash. I remanded him to the Essex County Jail. He went into my holding cell. My sheriff's officer had to do an inventory. He had $10,000 of cash in his duffel bag. Arrears paid.
It's important that a judge has to be willing to enforce every single order they enter. If the order doesn't have teeth, then people recognize that right away. And if you're going to have somebody that's going to play games, they're going to continue to play games. Sometimes it is very, very frustrating to get people to do what they say. There was one case I remember where the husband, who had a significant alimony and child support arrears, went to Florida. And he put all his money into a house, and then he said he was threatening bankruptcy. I said, good, let me know when you file. Until you file, these are my orders. Come back. And he never did file. And ultimately, there was an event that involved the children. He had to come back. And so as a result of that, he wound up satisfying the arrears that he owed. Case management is so important in these matrimonial matters.
What do you mean by that?
Because if the judge knows what happens in the case, they're not just processing a case that's on their desk. A case comes to them on their desk, they look at it, then they're done with it. No, they have to stay on top of it. So every time you have one event, you schedule the next event. And people know that you mean it. You have to come back, you have to comply, you have to do what I said by the next event. And when that active case management is employed, people start to do what they're supposed to do. I also know that when we talked about the recalcitrant parties, there were lots of ways people try to just nudge the other party and irritate them and just push their buttons. And when they push their buttons, then there's some kind of explosion that leads to some other problem. I used to give very, very detailed orders that really controlled behavior. And they were ridiculous if you were objectively looking at them. But for those parties, if it controlled their behavior, ultimately the problems died down. And the only other thing that I used to always tell my clients when I practiced, typically a great tactic is one party says to the other, my lawyer said your lawyer doesn't know what they're doing. My lawyer said you're going to lose. My lawyer this, that, or whatever. Or they also would, attack the person themselves. I would say to my client, if they do that, get a pad and paper and say, wait a minute, could you repeat that and say it a lot slower so I could write it down? Again, you're taking away the control, because that's all it is. It's an attempt to control you. So when you do that, you're taking away that control.
But imagine talking to the person that you trusted most in your life for 10, 20, 30 years. This was your partner, your spouse. They know your secrets. They've been through so much with you. And imagine them saying something to you like, your lawyer doesn't know what they're doing, or the judge doesn't know what they're doing. It's so terrifying for people because they don't know who to trust. And that's where hearts get broken, because they're thinking, wait, I have to trust this strange lawyer that I'm spending a lot of money on, or this judge I never met. Why can't I trust my spouse? It's very emotionally confusing for people. And it's sad. I mean, it's a really sad situation. And then we have the added element often of children. It's confusing. So what do you do? And I throw this question to both of you. When you have a situation where there are children and one party, for example, introduces the children to their new boyfriend, girlfriend, whomever, early on, that is not generally good for a kid when they don't know what's going on. But how do you make bad parents or inattentive parents or selfish parents think about the children before they think about themselves? Is that possible? Is that something a judge could do?
Well, first of all, from the first case management conference, the one thing I want to know first is, do we have a custody parenting time dispute? Because if we do, that case goes a far different direction than if we're just dealing with the finances. We have the custody parenting time mediation. We have the parent education workshop. That then has to be reinforced by the trial judge. I always tell them, look, this is where the human part comes in. I understand you're going to disagree about what's best for your children. My wife and I have been married 38 and a half years, raising 3 children. We always disagreed about what was best for the kid. She was the disciplinarian. I was the play parent. I coached the kids in all the sports. She hates my sports obsession. Now that you're going through a divorce, it gets exacerbated. However, no matter how much you hate each other during this process, you'll always be intertwined because you have children together. So now you have to talk to your children about the process that's happening without demeaning the other parent. And one thing I insist upon, if a significant other enters the picture, I don't really like them in the courtroom. I can't prevent it, but I don't like it, number one. Number two, I don't want the children calling that new person dad or mom. And number three, you really want to be concerned about the overnight situation in the beginning.
There used to be this prevailing thinking many years ago where both parents should say, oh, your mother loves you, your father loves you, we just don't love each other, but they're great and we're all great. I think that's nonsense, quite frankly. I think sometimes you have to look at your child and speak with them at the age that they could comprehend. So you speak with a 5-year-old differently than a 15-year-old. And sometimes you have to say to your child, Mom has an alcohol problem. We need to be mindful of that when you're there. Sometimes you have to give your child truths. And in the past, I've always felt like judges, they do this whole kumbaya thing. Oh, everybody should get along. Baloney. If they got along, they'd be married. And I've seen judges get frustrated with litigants when they're honest with their children. I'm a big believer in honesty appropriately, but kids have to know what they're dealing with. If somebody has an alcohol problem or is irresponsible, I think a child should know it at their appropriate age level.
You're talking about a couple of different things, okay? On the one hand, you have parents who, as individuals, don't like each other, but you don't want that ire that they have for one another to be projected on the children. That if I think your father is a bad dresser, I think your father is, sloppy, I think your father is lazy or whatever. On the other hand, you're talking about safety issues. Yeah. So they are two different things. So when a child's safety is at risk, the only person in that courtroom typically that has the objective eye for the children is the judge. And the judge's obligation, and this is pretty much universal, there's a Latin phrase, parens patriae, which is the court's role to take care of the children, the state's role in general. And they need to protect children because sometimes kids are at risk. Sometimes parents will not recognize the risk. And sometimes the court has to intercede and make sure that the child is protected. There was one case I had where I had each party crossing their claims against each other being an alcoholic, as you suggest. One story was more wild than the other. And so I said, fine, we're doing an alcohol test right now, right here. Everybody went outside, they did the test, and the mom blew a 0.3.
Which is bad for our listeners.
Very
That's
bad.
A lot of alcohol.
It's very, very, yeah.
Sure.
0.08 is what the statute says that you're under the influence. So this is 0.3. That means a lot of years.
4 times over the limit.
Yeah, and she's somehow functioning. It was incredible to me. She wasn't slurring her speech. She wasn't swaying. That was serious. And so what do? You say, first thing you do is say, give me your keys. And then you create situations so that the kids are not going to be harmed. They're not going to be with her until and unless some kind of rehabilitation is entered into. But I agree with you that you can't pretend when those kinds of things exist.
Right.
But you also have to be wary. You have to be wary of the ones that are made up.
I don't think that children should not be aware of parents' vulnerabilities or weaknesses. I think that's a mistake we make in general. Doesn't mean you have to be mean about it, but I think children have an obligation, or parents have an obligation, to communicate to a child certain things that affect their safety. And I've seen judges criticize litigants for that. How do you react to a parent who talks to their child about it?
Like Judge Lihotz said, the number one factor is safety of the children. We're put in a position where we have to make sure we're placing these children in a safe environment. For instance, like when Judge Lihotz talked about the litigant who, blew a .3, right away, we take the keys away. We put SoberLink in, right? So that if there is going to be any parenting time,
Can you
they
tell our
have to.
listeners what SoberLink is, Judge?
SoberLink is a process by which you could test the amount of alcohol or drugs in an individual's system. It's similar to like a breathalyzer, but they could have it at the home. And they do it in the morning, they do it at night. It registers the amount of alcohol or drugs in someone's system. There could be supervised parenting time. And I've told parents in my courtroom, you're going to determine what's more important to you, your children or your addiction. Because I did adult drug court in Essex County for 2 years. Besides children, addicts are the biggest manipulators in the world. And I say besides children because children might favor one parent because that parent's not a disciplinarian and will let them go along with whatever they want to do. As soon as that parent tries to impose some discipline, now they want to spend time with the other parent. In addition to children potentially being victims of divorce, they can be very manipulative also.
So we're talking about having countless litigants in front of you who are experiencing extraordinarily painful situations. You're human beings. I know both of you for a long time. You're compassionate human beings. Tough, but compassionate. How do you approach each day, or how did you approach each day on the bench, and not let that anger, that heartbreak, pierce who you are as people, control you, impact you? How do you get up every day and go back and address people and what's going on in their lives?
I think that every judge has to find something to relieve the stress that is natural that happens in the family part. Part of it is the volume of cases, and part of it, as you suggest, is the extent of problems that need to be unwound in order to get the case concluded. And sometimes it also is personalities of the parties or personalities of their attorneys that adds a layer of aggravation that seems to prolong the process as opposed to reach a conclusion. And I think that I personally would go home at night and I would not bring my work with me. I would end my work in the courthouse, and so that there is a great separation between my family life with my husband and my children and my work. So that's one thing that's important.
Is that really possible when you've had before you people who are bleeding emotionally? Is it really possible to turn it off? I know you. I'm surprised that you could do that. I mean that as a compliment.
I think it's necessary. You recognize that these are human beings and these are people, but at the same time, it's your work. And you can't assume the mantle of their problem. You can't. There's cases where you say, okay, how can I fix this? How can I help this? And that's really like doing a jigsaw puzzle. You want to say, how can I put these pieces together? But you can't assume that it's your responsibility to do everything that you're trying to tell these people they need to do. And so I think that's really the difference.
I would try to at least 2 or 3 times a week after work and before I came home, go to the gym. Just for 45 minutes or so, not being any type of power lifter or anything like that. And it would keep my mind off of what happened that day. It was like, in addition to me sweating, the stress was coming right out of my body. So I would try to do that at least 2 or 3 times a week. Unfortunately, because we had such a heavy caseload in Essex County in the matrimonial division, I had to bring work with me home sometimes after dinner to prepare for the next day. But at the dinner table, I try to at least keep that time of the day away from my job. Now, my wife might ask me, hey, what happened today? The other thing is, I think if you really think about the enormity of what you're doing, it could really drive you crazy. But I came to the point where I said, look, if this was easy, I would not be needed. When I was a trial judge, if this was easy and people could work out their problems, they wouldn't need me on the bench. If we have difficult mediations too, right? You look at the document, you say, how the hell am I going to get this case settled? If it was easy, the parties would have settled it among themselves. But if you view it like what you're doing is very important, but you can't solve all their problems. You could lead a horse to water, you can't force them to drink it. Listen, ultimately it comes to this. You married him, I didn't.
That's a great, Judge, I say that a lot too. It's funny you say that. I say that all the time. And I said that about my own marriage. You have to take personal responsibility because you made a decision. I married him. So you have to own that no matter how wrong or right the other person is. But you married him. And I say that to my clients all the time. I didn't. With all of us, we have to own our decisions, and personal responsibility. Another conversation is something often litigants have a hard time accepting. So when somebody's in that constant victim mentality, that's the spot where I give a real tough talking to. That's where I'm in a tough love mode. Get out of being a victim, own it, take responsibility for your decisions, and move forward. I did it to myself. I tell litigants that all the time. No victims here. Move forward. And I think that's a really important piece of advice that we could give people going through that. It's cold, it sounds harsh, but it's true.
Well, hand in hand with that, people have to recognize there's no combat pay. There's no compensation because you put up with a bad situation.
Right.
And the fact that they think a court might do that, that would prolong a case. So you have to dispel that proposition early on in the matter.
That, as I said, is probably the hardest thing to communicate to a litigant. Well, he was a really bad husband for 30 years and I took care of him. Yeah, well, okay, it's called marriage. Or, I made a decision to work or not work. People want combat pay. There is none. We are in a no-fault state, as most of our states are. Fault is not a factor. Again, there are exceptions in extreme circumstances, but fault is not a factor in the outcome of a court's decision. Fault will not be considered a reason to give you more money or less money. That's the most frustrating thing to communicate to litigants, I find, and I'm sure you saw that on the bench.
Yep.
Punish him for being a bad person. Punish her for not being a good wife. Can't do it.
Can't do it. They watch movies, they think, or TV shows, and
Right.
they think. Right off the bat, I tell them, marriages usually break up for one of two reasons: infidelity, money reasons, sometimes a combination of both. Infidelity does not get you a greater financial settlement. If he cheated on you or you cheated on him, that provides the cause of action. It doesn't play
You
a
don't
role
even
in the
need that,
finan-
though.
No, irreconcilable differences. But the only thing that I would be concerned about as the judge or the mediator or the arbitrator, if the party dissipated the marital estate on a paramour, that's the only time it comes into play.
If they're supporting a boyfriend or girlfriend in an apartment or giving them money, yes, the economic recovery is an issue, but they don't get extra money to be punished. They just get that money clawed back in. And again, that's what's difficult to communicate. You will get economic results based upon fairness and justice, but you will not get punitive result. And it's so upsetting to most people, but it's life and it's all about personal responsibility. And I think that I'm hopeful that if our audience understands that, they will take control of their life, cut their losses, and move forward. That's the goal.
Yeah, I mean, they have to separate their life because once a complaint for divorce is filed, their life is changed now forever, assuming they don't reconcile. And if you're not going to reconcile, you need to then say, okay, how am I going to go forward? And what's that direction look like? And I think that's what people really have to stop and figure out for themselves.
Once you do that, there's so much freedom associated with that. Again, I speak from personal experience. Once you accept that, nobody's bad or good or wrong or right, the freedom that gives the person going through divorce is extraordinary. And I think the rewards are endless. I'm wondering if in all your combined years of experience, which is extraordinary, are there specific situations where you can recall seeing a litigant come into your courtroom broken, vulnerable, terrified, and you've witnessed their evolution over the time of the divorce and you've seen them come out whole and healthier? And I'm wondering if either of you have any examples of that you want to share with our audience. I have seen it in my practice. I've seen people come in catatonic, in shock, and as a year or two goes on, they begin to blossom, to find their spirit. It is the most rewarding part of what I do. I'm wondering if you have any experiences in that regard in the courtroom.
Every judge, I think, has one of those stories at least, if not several of those stories. One specifically that I recall was a situation where mom had suffered an accident. Dad was a physician, and dad was prescribing narcotics, and she essentially was addicted and not functioning because of the medication. Now, that was long after the injury abated, but when she came into the courtroom, she couldn't even open her eyes. She could barely stand up, but she did have a great advocate, and we gave her time to try and get herself rehabilitated and to get herself sober, and she did. And as a result, she became a very active participant and her own advocate in the case. Actually, it was a wonderful thing because it was important. It was important because they had children, and it was important for the kids to see their mom wasn't what they thought she was. And it actually worked out very well overall.
I think divorce attorneys get a very bad rap. The rap that divorce attorneys get is that they're money hungry and they just want the cases to continue so they can keep billing and billing. It amazes me how some attorneys have so many different roles when they represent their clients. They try to watch out for them financially, and they almost become like their client's own social worker. I can't underestimate the role that the attorney plays in the relationship with the client and also the support system of the family and the friends. One big instance of something that struck me in my years on the family bench, we get these cases where there's allegations of alienation. I had some bad cases involving that. The father was like heartbroken, and he would come into court and he showed me pictures of him with his daughter at Giant Stadium, and she was laughing. And he would show me pictures of them on vacation, and she was laughing. But the mother would say that the daughter was afraid of the father. If she's afraid of the father, why is she at the Giants game with him or on vacation with him? Eventually, I sent this teenager to a boarding school out of state. The family had money. I had to get this teenager away from her mom's influence.
What happened to her?
Well, my wife and I are walking on Church Street in Montclair one Saturday evening, and there's the father, the father's girlfriend, the daughter, and the son having dinner together. The case was over. The father hugged me and said, "Judge, you got my family back together." There are not many satisfactory moments when you're a Superior Court judge in the family division. You're making gut-wrenching decisions, especially about children. When something like that happens, you can't express that you say, wow, I did something good for that family. That made all the heartache of all the other cases worth that moment.
I'm so pleased that we've ended our discussion on a positive note, on something hopeful. Not wanting to end a marriage or change your life is many times a result of great fear because change is terrifying. What I'd like to communicate is that once you get through that keyhole of extraordinary pain, heart-wrenching agony, there's a bright future. I know that for myself. I froze, I held on, but when I pushed through, life became wonderful and different and not as planned. I know you have both seen so many examples of that. So thank you both so much for telling our audience about witnessing heartache and hoping for hope. I think it's very encouraging to see two experienced judges give that perspective. So thank you so much. Today, I hope what you heard and learned is that judges, the court system, they can't fix heartbreak, but they could provide hope. Judges could order people to pay money. They could set parenting schedules. They can enforce orders, but they can't fix who people are. They can't make bad marriages good or make people who don't get along get along. That's frustrating. Look, this is emotionally complex stuff. Going through the end of a marriage brings out sometimes the worst in all of us, but it could bring out the best if you involve yourself in the process, if you take ownership, if you have realistic expectations, and you don't function out of anger and resentment, you'd be surprised how your life can change and, I believe, become better. Thank you so much for joining us today. Don't forget to follow us on your favorite podcast platform. Please give us a 5-star rating and leave a review so more people can listen in to Heartbreak and Hope with Pat Barbarito.